It's my pleasure to introduce our Chief Judge, Cory Swanson, and our judge from the Flathead area, Lake and Sanders counties, the 20th Judicial District Court, Judge John Mercer. Both have very distinguished careers. You probably know much about both of their careers, but I'll speak a little bit to each of them. Cory grew up on the High Line before moving to the Bozeman area. He attended school in Montana and transferring to Carroll College, where he graduated in 2000 with a BA in political science. He attended military education first and then went to the University of Montana School of Law, where he received his JD in 2004. He has a very distinguished military career. And so including many multiple tours in active duty, which is very admirable. So his service has not only been to our state, but to our country. He served as Broadwater County Attorney in 2014, and then was reelected in 2018 and 2022 before now taking the bench as our Supreme Court Justice. And I'll just a personal note, we're going to talk about meeting one another and talking face to face. And our Chief Justice is walking that walk. He is doing that work. We're also pleased to have with us today the Honorable John Mercer, who took over the vacant seat from Judge Kim Christopher, and then also from the resignation of Judge-elect Britt Cotter. Before that, though, he had a very long and distinguished legislative career in addition to being an attorney. He graduated from the University of Montana in 1979 and earned his JD from Northwestern University in 1982. He served in the Montana House of Representatives from 85 to 2001, including 4 terms as House Speaker, and served as Chairman of the Montana Board of Regents from 2004 to 2006, and in addition to a private practice in Polson for over 40 years. So we are very honored to have these 2 judges with us today to end our day talking about judges and what we can do to assist in maintaining the independence of the judiciary. Please welcome our guests.
Well, thank you, Natasha, for that introduction, and thank you everyone for attending. I think it's very important that we are here talking about the concerns of the attacks and diminishment on the judiciary. When we started this discussion, the group was called Friends of the Second Branch. We've already been demoted to third. I don't know what happened, Betsy. No, in all seriousness, I thank you all for coming. And my remarks, I'm only 9 months into being Chief Justice, and my remarks are going to be very much focused. I'll talk a little bit about court functionality, but I'm very much going to be talking about the political environment and the way forward for we're going to talk about courts, of course, but it's really not just courts. It's all of us. It's members of the bar, it's the legislature, and it's our clients, your clients, the people who count on this system working. Because if our system doesn't work, what's the alternative? Fist fights and gunfights in the street. And we've tried that many, many times in history. It's never worked out well. We have a system that's the envy of the world, and we need to keep it. So because I'm Chief Justice, I have kind of 2 different roles. First, as one of 7 members, analyzing cases, deciding cases, writing opinions. Among the 7, we are co-equals. And so in regard to some of the discussion that we might have about cases, those comments are my own. I don't speak for my colleagues on those issues, and some of my colleagues may disagree with some of my thoughts on that. The second role, though, as Chief Justice, is very much focused on the branch itself, the entire judicial branch, and advocacy for the branch, for all the district courts, for the Supreme Court, for our budget, for our training, for our personnel, for our operations. And so in that context, I've had extensive dealings with the legislature in the last session and really on an ongoing basis. And that's the area where I'm going to spend most of my effort in the reform discussions that we're having. So I want to begin by saying that conflict is supposed to happen in our system. Our system was designed for conflict. And why was that? Well, Look at our founders, most of them were experienced in legislatures in the colonial period. Most of them understood the danger of any branch of government, in their view, probably the monarchy, having too much power. So they designed a system to prevent any one component of the government from having too much power. And how do you do that? You have ambitious people here pushing against ambitious people here and limiting each other. So there's a certain level of conflict that is not only natural and inevitable, it's intention. Our problem is when that friction goes beyond what's healthy. When the friction goes beyond the moment and beyond the processes and beyond working out solutions, and it gets to the point where it is boiling out into the streets. And I don't think we're there yet as America, but you can see that in the horizon, can't we? We don't want to get to that point. So that's what I'm trying to focus on. First of all, long-term perspective of American history, and then also comparing what we're seeing here as opposed to nationally. And I appreciate the presentation that we just watched. So we have to make a very important point that every member, and I think we have mainly lawyers here, every member of the bar needs to remember. The legislature is not like a court. They don't make decisions like courts. Ted Swindon, famous governor, said, reason and common sense have nothing to do with it. We're talking about politics. And the legislature makes decisions based on what matters to them at the moment, okay? But the other thing to keep in mind is they make decisions based on a completely different process. So no rules of evidence, no adversarial process. It's adversarial, but it's not necessarily fair and equal. And they very much believe in ex parte communication. That's the most effective way to get anything done in the legislature, is you're not going to get it done in the hearing, you're going to get it done before or after. But here's what really matters to legislators, is who can they trust, who can they rely on? Because as we already heard from the prior people, now, by the way, I'm sitting, I hate to talk about the legislature like I know what I'm saying. I'm sitting next to a giant who's gonna correct anything he says about the legislature, take it as more true than what I say. I work for the legislature, I've lobbied a couple times. And generally people run because they care about one or two or three issues. And they care about those issues a lot, and that's why they're there. And then they have to deal with 100 issues they've never heard of, they've never thought about, and they don't know the right answer. So how do they make that decision? Well, some of them just go along with whatever the momentum is or their caucus tells them to do. Some rely only on whatever comes into that hearing information-wise, which we've heard from the discussion isn't ideal. Some of them do their own research. Well, if you've been to the legislature, it's an anthill. It's 90 days of frenetic activity. You don't have time to do a lot of your own research. We were talking earlier about a senator named John Cobb from Augusta. John Cobb was famous for reading every single bill. Okay, so think about that. He's famous for reading every single bill. Why? Because the others didn't have time. It's like when you go to law school and you read every assignment. Sorry, Professor Tonin, I've skipped a few. But so what do they end up having to rely on? Someone they trust that they have their best interests in mind, and someone they trust that's competent and knows the answer to this thorny question. Okay. So if members of the bar are concerned about the legislative process, my number one recommendation is become that person that they trust, who you show your competence and you show you care about the best thing for the state of Montana, and they'll call you up on day 44, which is right before the transmittal break and pressure is on. They'll call you up and say, hey, what do you think about this? But the only way they know to call you up on day 44 is well before day 1, you've established that relationship with them, and you've established that relationship of trust and competency, that reputation. That's the key. In my view, that's the key to this whole ballgame. So, how do we get there? The number one rule is understand and humanize the other actors involved. So, first thing is to understand the process of these legislators. And I appreciate what the legislative leaders said that were here today. Because it's a whole different world. It's like stepping into the working class. So go watch legislative hearings, go participate. Like Natasha said, it's very easy to participate. But what I would tell you is participate before it's time to participate through connections. And then humanize them. Okay? Now I'm giving a different talk to the district judges in 2 weeks in Billings. And the talk that I'm giving to them is bring legislators to court so they see how court works. Because guess what? A lot of judges know nothing about the legislature, and a whole lot of legislators know nothing about court. So that's the other part of, I'll talk about at the end here, the outreach effort I'm doing, which is to bring legislators in to see how we work. Because I want to humanize judges, and I want to humanize lawyers through that communication process. But for our point of view, if you're a non-legislator and you're a lawyer and you're worried about where we're headed, humanize legislators, get to know them, find out what they care about, and become the person of competence and trust that they're gonna call when it's a 50-50 vote and they don't know what to do. And I'll talk a little bit more about this when we get a little farther down the road. But the other part of this, so that's my outreach. Okay, so I'm starting an outreach effort statewide. I'm working with, and the gentleman here to my left has been giving me very good counsel on, hey, you need to do this, you need to do this. And I'm like, I'm just a kid from Townsend, Montana. And I keep introducing myself as Cory, and then he's like, oh, you're not Cory, you're Chief Justice, because that's your position. And that's true. I'm just Cory, but I'm carrying forward the responsibility for all of us. And I take that seriously, and I'm doing that on that outreach effort that I'll be leading through the judiciary. What matters for all of you listening is to know that I'm just one guy. Counting on me to do it, that's too far between. There used to be a commander of a large infantry and armor unit. And I still had to go I had a tank, and I had to go do tank gunnery, and I had a rifle, and I had to go shoot rifle and all this stuff. And then I said, but keep in mind, guys, that if we get to a point where you're counting on my tank to save the battle, it's too late. We've lost because I have 28 other tanks that should have been ahead of me. And that's what I'm saying. I'm leading the effort. I want to communicate this to all of you, and I want to urge all of you to action, because it's going to take all of us humanizing our connection with legislators, with people that perhaps appear to be hostile to our understanding of how this system should work. But I believe that face-to-face connection restores trust, restores respect, and is going to build a bridge for us to get over these currently troubled waters to a better next phase of this saga. So that's introductory. I have more things to talk about, but I want to hand over to Judge Mercer and see what he can add in terms of wisdom. I might plug someone for some water as well. I seem to have used up all my momentum here.
Water. Okay, well, first of all, I just want to make it clear that I am not speaking for the judiciary. I'm not speaking for the 20th Judicial District or even Department 2, which I'm in. I'm going to speak, or even for my wife. I'm not speaking for her. But I just want to make it clear that I feel like whatever the judicial canons and laws and regulations that might affect what I'm allowed to say are trumped by the First Amendment. So I'm just going to get right into it. And I have a series of little points that I want to make, and I certainly want someone to take my picture while I'm next to the Chief Justice. This is really awesome. I really admire this man. Okay, so on a couple of the things about like security is an issue that they talk about. Do you have fear as a judge? And I have to tell you, I wear a white shirt every day, so sometimes people confuse me with someone that's doing something else door to door. But I have to tell you, I pictured a big splotch of blood on my shirt for some reason. And then I got to think about it some more. And really, lawyers are just as much at danger as judges are, because if there's a domestic issue or something, someone can walk in that door at any time. So I guess I don't really feel any more threatened than I did when I was a practicing attorney. I wanted to mention about how judges ought to be selected, just so people know. Judges need to be nonpartisan. If we do not have respect for the judiciary, our system will not function. And everything that attacks the judiciary erodes that trust. And that's a very dangerous thing, because if we get in a spot where people don't trust or believe in the judiciary, that's going to be very dangerous. And I think I was telling someone here that one of the first times I was on the bench, I told some lawyers, sort of like, well, this is how it's gonna, this is what I think, and they wrote it down. It's like, wow, that's really cool that you have that authority, but I realized more important than that was that people just need someone that will decide, and they have to respect that particular person. Okay, so what do I think is the problem? Is there an attack on the judiciary? Yes, there is. But I think there's a reason to believe that it might be a counterattack a little bit on the judiciary, because it's certainly my viewpoint of my life experience that the judiciary at times has acted beyond its constitutional powers or what was intended. And I think that what the problem is that political decisions need to be left to the political branch. And why is it so difficult for judges to control themselves? Well, I know now because I'm a judge. You have that authority to sort of look at the totality of things and try to make a decision. But that discipline is also a problem within the system, because there really isn't a great check or balance on the judiciary. It's self-discipline. And I guess if I was going to say anything, it would be, judges, please have self-discipline or judicial restraint. And it's that same thing, like, how come I'm a little overweight? Because I don't have the discipline. And it's very difficult to put discipline on yourselves, but I think that's where some of the pressure that's coming back towards the judiciary is coming, because we always want to make a decision when you're a judge. You just want to decide it, even though many times you should say, that's for the political process to decide. And if you don't like that, you need to change things. And I tried to think of a great example, and the one I came up with was the 19th Amendment to the US Constitution. That's the one that gave women the right to vote. So imagine if someone asked, under the Constitution, do women have the right to vote? Well, modern judges would say, absolutely. Are you kidding me? But in those days, they did not. And what did they do? They amended the Constitution to give that right. And I think that that's a little bit of a problem, is that we have to sometimes as judges not think that we can constantly write what the laws are and wait for the political process to catch up. And ultimately that will help respect for the judicial branch. Then I have a few other tidbits that I like to always mention. One is Politics 101. And I see that that is something that is really disappearing. And Politics 101 is as simple as this. People like to be in the know, and you like to get their fingerprints on stuff. And that's how you get stuff done in the political process. And we can even use that as judges when we're working with legislators and people like that. But it makes a huge difference if I walk in this room and I announce, we're having sushi for lunch. Okay, that's what we're having for lunch. But if instead, throughout the day, I'm walking through the room, thinking about having sushi. Oh, well, okay, you're in the know. And somebody says, well, if we're gonna have that, would it be possible to have some potato chips or something? I go, yeah, we'll add potato chips. So now I've got people in the know, and I got the fingerprints on the decision. And that's how some things happen, because as I observe the political process, both at the national level and at the state level, it just seems to me like people don't know how you work together and how you accomplish something. And I'm hoping that some things will change in that manner. We need to accept that others have views that are different from ours, and we might learn something from that. It's just unbelievable to me how this polarization has been allowed to happen. And I completely agree with basically every speaker today, and including the Chief Justice, that we've got to humanize things. And I know back when I served, and believe it or not, I hate to admit this, I was elected 40 years ago. That's how long ago I started in the legislature. But at that time, people were friends, you know, they talked to each other and they could disagree, it was okay. But we tried to work things out, and I really feel like that's completely lost. And term limits were something that was not a good thing for that. Then I wanted to mention about when and how to lobby the legislature. Everybody's already said it. If you're lobbying while they're in session, you're almost wasting your time, but you do need to send someone. So you're not criticized for no one being. But you gotta get these people ahead of time, and they are so accessible, it's unbelievable. And what you can do as lawyers, and this is the big power that you have, is let's pretend I'm John Mercer, I just got elected, oh, by the way, John Mercer, not Bill Mercer. And I like to give a good story, I'm not related to him. I was at a fundraising party on Flathead Lake, a lot of rich people there. And somebody came up, this is Judge Mercer, and oh, they're talking to me. And pretty soon they find out I'm not federal Judge Mercer. And so right away, well, it was good talking to you, we need to move over and see some people over here. Oh, geez. But what lawyers can do is, I'm John Mercer, and hey, John, are you putting any bills in the legislature? Yeah, I was gonna do some pretty good ideas. Maybe I could help you draft it. And I gotta tell you, that would be such a great assistance to the legislature, but it'll really get you inside on putting together a bill that people have, because it's unbelievable. I'm sure the lobbyists can tell you, some of the bills that come in, even though they're drafted by professionals, they're still kind of messy. But individual lawyers can have a huge impact. You get to know your legislator and you can just help them. You don't have to agree with them, but you can help them draft something that they want to get done. Another thing I wanted to mention was, and this sounds like bragging, in the introduction, I've had high positions. Okay, I've been in high positions before. When I became a judge, oh my God, the respect that a judge has is unreal. It's a completely different thing. And that is so critical to what we have to maintain. People have to accept a judge's decision. I don't have any army. Your chief doesn't have any army to enforce anything. It has to be the respect for the judiciary. And everything that's being talked about here are things that erode that. And I still want people to know that I understand that there's this erosion going on, but I still feel it's because of the lack of judicial restraint to some extent that has caused that. And so I want to mention that. But another thing I wanted to mention was something I call the 10-yard chain. And as lawyers, you're going to love this too. And that's that in football, they don't know what the play is, and they just bring a chain out, and if you make it, you get it, and if you don't, you don't. It's just that simple. But it seems like in the judiciary, because we're coming in to measure for the first down after the play is over with, we like to look at, well, you know, who should have won and who's in the worst position and all that kind of thing. And I think that as an attorney for many years, and also as a judge who's trying to follow the Supreme Court rulings, is that it's hard for anything to be very black and white. When you try to advise your clients, I think honestly, a good lawyer in Montana right now should advise their clients that we don't really know what the Supreme Court might do. So you might want to push this forward. And I think there could be a lot gained by trying to get some more specific rules, even though they result in some things that seem quite unfair at the time. Like a classic example would be, something really simple would be, if you don't file your answer within 21 days, you're defaulted. That's it. Yeah, that's a simple rule. No, we're not going to adopt it, but there is a need for more specific rules so that district court judges and lawyers, I think, can do a better job. As far as working with a district court judge, it's kind of fun when you go behind the door. I wish all your lawyers could be a judge for 6 months and see what it's really like behind the door there. But what judges admire are civility, when the lawyers can get along, and also when you can kind of keep it kind of simple so that the judge can understand what it is that you're trying to get accomplished. That would just be my tiny bit of advice. Last thing I wanted to mention before I turn it back over to the leadership here is that this group is called the Friends of the Third Branch. And I thought, well, what about the Friends of the Legislative Branch and the Friends of the Executive Branch? And maybe we could get a ring and they could get some mud and they could wrestle away. But I thought, why don't you consider changing the name of your group to Friends of a Functioning Government? Because I think we all believe that the government is not functioning like it was intended. And if we don't get off the sidelines, and a lot of you are not on the sidelines, but everybody needs to get off the sidelines and try to restore the government. And that's going to require respect for other people and respect for other people's property, respect for their opinions, and working things out. I remember a very simple legislative example I used to give people is that some yahoos from Missoula wants to lower the speed limit to 55 on the interstate. And some wacko from eastern Montana wants it to be 90. Okay, well, a common example, can we compromise somewhere in the middle? That's one kind of compromise. But a whole nother kind of compromise is, yeah, if you want to go 90 on the interstate, that's okay. But how about you give us a little more school funding money? And again, I just feel like the current legislators, both at the national and state level, don't really seem to understand how you work together and how you make some horse trading. So that's my thoughts on it. I will be glad to, I hope I don't get, smacked down, but I'll be glad to answer questions on anything once it gets around to that point. Thank you very much for coming.
I'm gonna follow up with a couple more of the reform type things, and then I think we talked a lot already today, and we're gonna ask if anyone has questions. But so in terms of the problems in Montana, okay, so last legislative session, we have a bunch of bills that came forward. And, it was my first session as Chief Justice, so I'm trying to figure out, okay, do I engage on these bills, or do I just stand aside and see what happens? And there were a couple of bills. There was the bill to reduce the size of the Supreme Court, and I said, I gotta get involved here because they have to know the volume we're dealing with and all that. But most of the bills, I just kind of watched how it was going, and like Natasha said, most of these bills, how it was going is there was a whole bunch of people lined up as supporters at these hearings for various reasons. And then when opponents came, there were Bruce Spencer, Al Smith, and John Mudd. Now, you know anything about the legislature, anything about the group that was pushing this, those three messengers were, that was their time when everybody else went for the coffee break. They weren't listening to those messengers. And as I watched this a few more times, that's really when I said, we've got to change our approach. So that's why we're reaching out to the state bar and saying, what we need are lawyers and business people and people of influence in communities who personally know legislators or get to know legislators who can say, it's not just a cabal of people that want to maintain a monopoly of power over the courts and money. It's actually, here are the reasons why this legislation won't work. And there's reasons I can't do it. If I get engaged in legislation, well, then I'm off that case if it gets litigated. And I've got a duty to preside on those cases on the court. So that's a lot of the effort that we're talking about. The second thing is, I do think there are things that need to be done in the world of judicial reform. I think that term means different things to different people. So here's what it means to me is something I'm working. So we're doing we're doing a comprehensive budget review. There are a lot of things in the judiciary that in my view are underfunded. Well, the first thing I want to do is try and save money somewhere else to spend it in the places where I think we need more before I go to the legislature and say, hey, I need more money. First thing I want to bring to them is, here's the places where I've saved money. That's a hard process when you're dealing with government budgeting. So that's going to take me a good year to get that done. That's item one. Item two is operations and efficiency of district courts. So last week we were in buildings. We announced that the 13th Judicial District is going to specialize its dockets. First court in history in Montana that's done that. So they'll have 10 judges beginning January 1st. 5 will be in the criminal division and 5 will be in the civil division. And then after 3 years, those district judges will switch divisions. They're still general jurisdiction district judges, and they'll occasionally get a substitution bill or something that will keep them, dabbling in the other division's business. My goal, they believe, these judges are very smart and they work very hard on this. They believe it's going to increase timeliness of resolution, both for criminal and civil matters. And it's going to allow prosecutors and public defender's office to better cover those criminal trials. So It's an innovation effort that's locally driven. I don't claim credit for it, but I'm supporting it. There are things like that around the state are things that we need to do. That's what I think judicial reform looks like. The outreach effort like this, it's gonna expand to every organization, every interest group I can talk to in the state, I will. But again, I'm one messenger. We need many messengers doing that, and we need many people communicating with legislators and saying, what are the things you're actually worried about? Sit down for a minute. I'm not here to argue with you. I'm here to listen to you. What are the things you're really worried about? And maybe we can find, like Judge Mercer is saying, maybe I'll help you draft that bill. And that may or may not be fruitful, but that engagement matters. Court security. We're working on a court security comprehensive plan. We have a security coordinator that's here. We just met, I just went to Mako two days ago and spoke with them, the county, because of the way the statutes work, it requires the county commissioners, the sheriffs, the courts, everybody has to participate in that. So that's something that we're ramping up. And then there are a number of bills that were discussed today that we're introducing or that we're trying to implement, we have to implement. So breaking news, and no one knows this, I'm making an announcement. I appoint 3 people to this judicial performance evaluation commission, only one of whom can be a lawyer. So I'll be sending a letter on Monday to the governor and the leadership, and so I'm gonna keep this quiet, everybody, till Monday. But the 3 people I'm appointing, Ed Eck, perhaps you've heard of him, former dean of the law school, Karen Fagg, a business CEO, retired now from Billings, worked for Governor Martz and Governor Stevens. Her husband is Russell Fagg, longtime district judge, and Brian Lockerbie, who is the head of the Department of Criminal Investigation. 3 consummate professionals, 3 smart, hardworking, reasonable people who've all been public servants. I personally wasn't crazy about this evaluation commission, but I thought, well, if it's there, I'm going to put forward 3 really good people that I think are going to, our judges are going to be well served by their input. So that's the kind of thing I'm not going to just complain about it. I'm going to turn it into something positive. And then the substitution of judges. So judges aren't perfect. In implementing this substitution of judges legislation, I started doing it wrong. And thankfully, a couple of my colleagues started helping me figure out that I was doing it wrong. So we're not actually going to be able to implement this thing on October 1st because we're doing it wrong. Let me rephrase. I'm doing it wrong. And I've already told multiple legislative leaders this, and I said, sorry guys, I screwed up, but I'm going to get it right. So I issued an order last week for public comment so that the Supreme Court can take public comment and issue an appropriate rule dealing with substitution of judges. Now, this is not a constitutional pronouncement in case this ever turns into litigation, but there are some who say that the legislature is dabbling in the court's business on how to do this substitution rule. There are others who say the court's going to be able to implement a rule, and if the rule looks similar to what the legislature thought we should do, or if it looks a little bit different, then we'll just figure that out in the wash. But in the meantime, I will tell you this, district judges that are a single judge district out in rural Montana, when they get substituted, they have to go find another judge who's willing to take their case. So if they have an automatic pool of the judges in the surrounding districts that get selected randomly by a computer, it actually makes their job a little easier. So if you care about that, go look at our website. We've issued the order for public comment. We want to receive your public comment, and then the court will be considering it later. Meanwhile, I have to tell legislators, sorry, I screwed up. I can't blame anyone else. I screwed up. We're going to be late implementing this, but we're gonna do our very best to do it correctly. I'd rather do it correctly late than on time and do it wrong. What we haven't seen yet in Montana is slashing our budgets, impeachment of judges, those kinds of things. I don't want to get to that future. I want to have a conversation where we're all, this is one big family. And families aren't happy all the time. And I've been to family reunions where someone went to jail, and it's not always fun, but that's good. Someone still bailed them out. So if that's the kind of family reunion we're having, fine. But let's work through this and let's do our work, most of our work before January 1st, 2027. Because if we wait till then, it's too late. And when I say we, I mean the royal we. I mean all of you, and everyone listening online, and I mean the 5 people that you are going to tell when you leave here today, people of influence in your community who can reach to a legislator and say, let's sit down and talk about your concerns about the courts, about the judiciary, about the rule of law. First thing I'm gonna do is listen. Okay, so I came back from, I'm not gonna tell a story, I'm gonna start crying. But well, as a veteran who's been overseas and done some things and seen some things, I will tell you this. When I would come home and people would say, hey, what's it like over there? They would listen for 10 seconds and they would stop and start going, oh, I think this and I think that. And so a lot of veterans don't share anything because the person that asks them doesn't really listen. Because the short version is it's really complicated and it's really messy. And that's the short version, right? People don't listen to that when the veteran comes home. So when you start a conversation with someone who disagrees with you, I would urge you, don't cut them off after 10 seconds. Listen. After at the end of a lot of listening, get them to listen to you. And that's how I think collectively we're going to move to a solution. It's great to have a lot of people complaining about problems. I want all of us to forge solutions. That's the end of my remarks.
Absolutely. I know you have them. What you can count on is that what you say will be used against you in a court of law. No, let's, we have these judges here. I had questions. I was worried about open mic. They said, bring it on. So, let's go.
Hi, Zach Fulheim from KTAX. I'm hoping you two could give me an example of what you view as judicial overreach that has been taken.
So how, do you read our opinions that are published online?
Here and there.
Okay, so every Tuesday afternoon, Supreme Court issues its opinions. And as a practicing lawyer, I didn't read them all. I was a prosecutor mainly, so I read a lot of criminal cases, but there are a lot that I didn't read. So when I said at the beginning, I have 2 roles, right? As Chief Justice, I'm 1 of 7 as a justice, and as Chief Justice, I'm dealing with administrative things. So that's why I intentionally don't talk here representing the court about disagreements I have with my colleagues. But I will say, if you read some cases that were published this year, we have disagreements amongst the 7 of us as to methodology of how to decide cases. Okay, and I guess this is something I should have probably underscored. People are too obsessed with outcomes on cases. Methodology is the most important thing we should be looking at. How do you analyze the law and how do you apply it to facts? I want a judge who uses the same methodology for the most, detailed, fact-oriented, boring 100-year easement dispute as they use for the most highly charged, politically uproarious dispute. I want to use the same methodology. I try to do that. I don't know if I do it right all the time, but I begin every case with a mental exercise. I don't know the right answer to this legal question, number 1. Number 2, I believe there is a right legal answer, which we all know, right, as lawyers, that's not always the case. Sometimes you have to get as close as you can and make a judgment call. But number 3, I'm committed to the journey of research and now talking to colleagues to get as close as I can to the right answer. So if I can try to use that methodology and then go to what is required, to resolve that issue and not go beyond it to legislating, that's the methodology I try to use. I don't know if I always get that right, but we're in the midst of a dispute over some criminal law issues. If you read State versus Basta, we issued it a month ago. I wrote a brilliant dissent. But it wasn't that brilliant because it was a dissent, right? I didn't give 4 people. We're disagreeing about methodology. That's an example where go read my opinion there. I think what Senator Fitzpatrick said, I think there's more to the political dispute than the ones he mentioned. I think it goes all the way back to the 2021 legislative session. And during the eras when Governor Schweitzer and Governor Bullock were governors, they vetoed a number of bills that they thought were too far to the right. Well, some of those have now, or variations of them have become law under Governor Gianforte. This is not me saying yes or no on merits or constitutionality. I'm simply saying some people view those as too aggressive in this arena, and they challenged them. Many people have said, yeah, the court got it right, they're defending democracy. Many others have said the court didn't get it right, the court intruded into the legislative arena because of the preference that they have for outcome. That churn, plus the food fight of the 2021 legislative session, that churn is a great part of the story as to why we're here today. And the thing I said all through the campaign, because this came up many times, and my slogan was no politics, just the law. And I said, I want to put all that in the rearview mirror. Because guess what? No one's bills are getting paid based on what happened in 2021. Actually, some lawyers' bills are still getting paid. But I care more about 2025, 2027. We've got to put some of this fighting behind it. So I'm trying to do that through my methodology of how I decide cases. I cannot pretend that I get it all right. In 4 years, I'll look back at year one and go, I don't know about that. But I think some of the principles that I'm trying to use and some of the principles that my colleagues are trying to use, I do believe amongst the 7 of us, we're trying to get it right collectively. We may disagree, but that's the whole point why you have 7. And that's why you have an odd number. Because at the end of the day, you gotta have a decision for the parties. They have, we can fight all we want, but eventually, by God, get the decision out so they can get an answer and move on with their lives. And so that's a very long way of answering that question. You wanna carry on?
Well, let's give my example, but before I do, I just want to go back and harp on that point of the system is designed where the judges have the final say. And that's why I think a lot of times, because you have the final say, you want to go beyond maybe what you should. That's kind of my feeling. And the one that sticks the most in my mind is I think that the legislature, and it was probably back when I was there, passed a law that said you can register to vote and vote on election day. Okay? And that sounds kind of cool, but in practice, you have people that are trying to count the ballots, and people are being bussed in, and it's really kind of confusing. And I think that there are political overtones to it that, bringing those last people in on the bus, that's going to help one side. If you keep them out, it might help another side. But the problem that I had is the legislature repealed that. And all of a sudden now that's unconstitutional. To me, that was a great overstep of the court's authority. And I think it's really hard to accept sometimes that you have to allow the results of the election to rule the day. And I love to tell the story about, I'm sorry about this, but if we picked the pilot of the airplane on an airliner the same way that we pick elected officials, we'd have a guy like me going, hey, we'll take off whenever you want to. Don't worry about that. Peanuts, we'll land when you want. Don't worry about the ticket, because we'll charge that to the later people that are gonna fly. All right, and then there's another person saying, oh, don't pay any attention to him. We'll do this or we'll do that. And then at the end of the day, they ask me, what experience do you have flying a plane? Well, I haven't flown any plane. I haven't flown any planes, but I'm just, trying to appease the public. And I often say that if you don't like what's on TV and you don't like who your elected officials are, the problem is they're perfect reflections of the people. And the people need to step up in this country. And of course, lawyers are big leaders within their communities, and I hope that they can do that. Thanks.
Question?
Thank you, Your Honors, for taking your time and being here today. This has been really enjoyable and informational to have you speak so candidly to us. I want to follow up on a question along the same vein to you, Judge Mercer. And it's your counterattack on the attack on the judiciary. And I get what you say about judges going too far, and I don't think many of us would disagree with that. But you, in the trenches, not up at the appellate level, you have to decide a person's fate or whatever based on the law, based on the Constitution, based on the facts. How do you then, in an impartial manner, figure out what's going too far?
very difficult because I think that anyone who's a lawyer in here realizes that like an easement case could be decided anyway. Divorce case could kind of be decided anyway. Almost all cases seem to be like, you can find some little rule to hang your hat on. And the very ironic thing about this is, remember, I'm big on the 10-yard chain. Bring that chain out, and if they don't make it, they don't get it. I get a case where, and it's already been appealed to the Supreme Court, it's all done. But I get a case right off the bat where a grandma's daughter is murdered by the people who ultimately adopt their child. Adopts the grandma's child, and then once they adopt them, they cut off any right to visit that child. And if you read the statutes of Montana, they seem to say that the parents, which adopted parents, are the parents, and they're the ones that can decide whether or not that child can be visited. And so I said, the hell with the 10-yard chain. This is a case where you cannot deny that grandma, where the son of the people who have adopted her granddaughter, deny her the right to see her kid. So here, John Mercer, the king of the 10-yard chain, he's going, under the Montana Constitution, you've got a right as a grandma in this particular set of circumstances. And it's so hard to lay off of that totality of the circumstances. And I see that in certain opinions. And it's good in a way where you can just say, I'm gonna look at everything and then I'll decide it. But if you operate that way, lawyers don't really know, what do you advise your clients? It's kind of like, well, you kind of look at everything and then you kind of try to decide it. And so it's just very difficult to rein yourself in. But I feel like almost every case that comes before me, I know exactly what I want to do. And I hate to, have the guy come out from behind the curtain, as the Wizard of Oz. And I just go, all right, let's find the law that will support what I want to do. That's probably 50% of the time. Other 50% of the time, you pretty much know from the law how something ought to go. But I wish all of you could be a district judge for 6 months. It would be a wonderful learning experience because it's completely different than being a lawyer, that's for sure. And I have to tell you, it's not that great of a job. It doesn't pay very good. But the part that I do like about it is you can sign your name to something and make it happen. And if somebody doesn't like it, hey, they got somebody else that they can take it to. So you don't really have that final guilt or responsibility in that case. Thanks.
Questions?
You're assuming, Tasha. I will thank, I do want to thank Chief Justice Swanson for your comments to the legislature in the last session with respect to judicial independence. And I think they were a significant factor in calming some of the emotions that might have been driving a toxic situation at that time.
I appreciate that. I had probably too much credit and too much blame, headed my way due to that speech. I had a legislator late in the session complaining, your speech is what killed the partisan elections. I said, well, it wasn't exactly Winston Churchill, fight on the beaches. It was, but I'll say this, I consider myself, I guess, a textualist. In the federal conversation, we talked about originalism. I don't think originalism is as big a deal in Montana. Our constitution's only back to 1972. I don't think the wording has changed much compared to looking at 1787. But I was reading an essay or an excerpt of a book recently from Brian Garner, who a lot of people know as one of the legal expert on citations and methodologies, and then Justice Swanson and Scalia, late Scalia. And they were saying the concern about judicial selection, whatever it is, whether it's a merit-based, an appointment, an election, if judicial selection is primarily focused on outcome guarantor methodologies, you're in big trouble. It has to be based on, qualifications. And by the way, I'm not the most qualified person in the state of Montana to be the Chief Justice, but I got here, so I'm just trying to do the job as to the extent I can. But you have to look at methodology, you have to look at commitment to the process, you have to look at those attributes. If you look at outcome guarantors, you inevitably move the system towards bias and activism, whichever way that is. Because then you're selected. We can't look at outcomes as a judge at the beginning of a case. That's at the end of the case after you follow the journey that I talked about. And I had some groups that during the campaign were saying, we want you to pledge this outcome. And I said, well, I can't do that. And by the way, I'm the whole spectrum, both sides of the spectrum. But when we came to then the legislative discussion, I just felt that I feel that the discussion was driven by a handful of cases over the previous several years. And I don't even know that, you know, the merits of those cases can be discussed at length, and there's probably law review articles and debates. But if we get to a point where we are changing the methodology of selecting a judge due to an effort to get to an outcome guarantee, then it doesn't matter, because we've now begun to fail. Because the political gate's gonna swing the other way. I don't believe in permanence in politics. The political gate's gonna swing the other way. And then the other side's gonna use the same methodology to get an outcome guarantee the other way. And then at that point, what have we lost? We've lost predictability and stability of the law. We've lost certainty of process, and we've lost the hope of an unbiased judiciary. So we're all gonna lose at that. So that's my goal, is to try and, I guess there is politics in the courts. There's no denying. We're elected. Unfortunately, it's just fundamental. The goal is to remove as much politics from the process as we can. We have a money situation in the state, okay? So 2 Supreme Court races last year, I raised and spent $450,000. I got into the race later. That's not very much money when you talk about these races. The outside spending total, $12 million on 2 races. And the money, it was just weird the way it all happened. It got, you guys all saw it. Nobody was running as running mates, but we kind of collectively got grouped into the sheep and the goats, right? And I'll call myself which one's good, goat, sheep, or goat? I'll be the bad one. I was the goat, I think, in that. $8 million spent against me and the other so-called conservative. $4 million spent for me and the other so-called conservative, okay? So, I don't know if they got their money's worth, because I won and the other race went the other way. But I don't even know who they were, and I don't care. I gotta just go in and do my job, because if we start keeping score, we all lost. If we keep score on that, we've all lost.
I'll ask a question, Judge Mercer. Do you feel like you have enough resources? Are there enough judges in your district? And I asked this question wondering, do some judges come at the cases from the end rather than the methodology because they don't have the time and the resources to do it the right way?
Okay, well, I do think there are some judges that are overloaded. Myself, I don't feel that way, because I like to decide things, and sometimes I've heard enough, sort of thing, but I feel like it's not a problem. But one thing that I do think is a problem is the pro se, the explosion of pro se litigants. And the analogy I like to give is, because we open our courts up, come on in, pro se, argue, no, okay. That if the hospitals were required to open up the hospital, hey, doctors are expensive, but you can come on in and use the hospital all you want, use the operating room, do your own operations. That I see that as something that is not very good for justice, but it also is sort of undermining. Remember I said respect. That judge has got to be, after today, no one's going to respect me up there, but judges really need to be respected. And the pro se people kind of bring that down in the courtroom because it's not that formal. Another thing that kind of bothers me, and it's a gray hair thing talking, is, people are appearing by Zoom. I drive 90 miles to Thompson Falls from Polson. I'm on the bench. The defendant is appearing by Zoom from the detention center. The county attorney was ill that day. She's appearing by Zoom, and the defense counsel's in Missoula appearing by Zoom. So everyone's coming in on TV. Or you have somebody in their car. I had a person I sentenced on Thursday in their car. That's where they were. Then, of course, the other thing is the computer on the desk. Sometimes I feel like, are you a travel agent or are you a judge? And I guess I would just lobby the chief right here. I think that if you could get the computer in the desks of all that they're looking at. So they just look down like it's a piece of paper instead of a big computer over here. That would be a good thing.
Justice Swanson, same question to you, and you know, you're seeing, you know, budgets from a different level, and do you feel like there's enough resources here so that there is good methodology used in cases to get to good outcomes that are predictable?
Well, I would follow up by saying, I agree with him, I think we don't have enough lawyers in the state, and I'm amazed at how many pro se litigants we have, and I do think that tends to, I mean, the judge ends up kind of helping them along some way. I have been speaking to other district judges and just saying that same question, do we need more judges? Are these metrics correct? And what some judges are telling me is, let's look at ways that we can improve the efficiency of simply how we do our job before you add judges. When we go to the full court enterprise where everything is e-filing, as an attorney, that added like 150 clicks for everything I needed to do. And for judges, it's adding a lot of time. So what's happening is judges are doing a lot of non-judge tasks to format, do this, do this, do this. And so I'm trying to figure out, I don't know, if there's some process engineer out here that wants to assist. We're probably gonna look at NCSL and see if they have not NCSL, the National Center for State Courts, but to see if there's a study they can do where we can relieve judges of some of that just minutia burden so they can do what they can do. And then one of those great tools and rules of leadership is you do what only you can do and you delegate everything else to someone else that can do it. And so that's one thought. But secondly, I am concerned about case timelines. I was just meeting with some lawyers at a firm in Great Falls the other day, and they were saying the civil timelines are horrendous. And that's because they tend to get stuck behind criminal trials because people are in custody and they have a speedy trial, right? That's part of the methodology and reasoning behind why we are specializing now in Yellowstone County. I'm not saying that's gonna work for every district. I'll probably talk to other judges in the big districts and say, you guys need to at least look at what they're doing and see if you wanna do it. But I think district judges in those districts should be the ones making that assessment before I come in and say, hey, you have to specialize.
We heard from Judge Mercer.
I just
Oh,
want
yeah,
to offer one other thing that's sort of similar to this whole technology thing, and that's that a warrant for your arrest or a search warrant to look in your house can be put on a little stamp signed by Judge Mercer, okay? And that's kind of worrisome to me. Maybe it's just unusual, but that's how things are getting. I mean, when I was first a lawyer, you had to have like real notarized documents and real this and real that, and everything is just flying through the air. And I hope I'm concerned about the authenticity of things. Then I wanted to mention quickly that I've been on the bench for almost a year and a half, and I've had 2 jury trials in Lake County and 2 jury trials in Sanders County. That's not very many. And because it seems like within the criminal system, they keep kicking the ball down the road and they use the court as sort of a holding place for defendants, give them some treatment and stuff like that, which I understand, but I feel like courts could be more efficient if we made things move along. And frankly, as I'm looking back on it now, I'm going, why can't we just start scheduling some of these civil cases the same time as the criminal cases are? Because it doesn't seem like they go. You got like 9 criminal trials set for a particular day, And then by the time you get to that day, they've all either pled out or asked for additional time. So I think there are things that can be more efficient. And the final soapbox, and maybe this is inappropriate too, but I think the whole system could be examined. I mean, the whole criminal justice system could be relooked at, the whole civil justice system could be looked at. And I don't know whether that will ever occur, but I guess I would hope that at some point, someone would say, why don't we just kind of look at the whole thing and see if there's a better way to operate it? Thanks.
Justice Swanson, Judge Mercer said he doesn't feel at risk. What are you hearing across the state of Montana on security?
There are some security concerns. I mean, this week we had a strange one, and so it's not every day, but it's certainly every month. And so we have to take those very seriously. We talk to all the judges about their own personal habits and movements, and we're doing security assessments for sites. I would not discount it, but again, you're gonna get 100 people of good faith that are coming in and out of the door, and then occasionally you get someone. It's usually, I wouldn't say it's usually without warning. Lately, what we've gotten is about, multiple emails ahead of time saying, I'm coming for you, and then we find them, but I do take seriously, and that's an important part of what we are dealing with legislatively. So I do a sort of closing remarks if this is the time to do it.
It is.
So what I would say is, I'm talking about solutions rather than, we have to assess the problems, we have to talk about solutions. And some of you may or may not disagree with what I said, and I may be seen as kind of I don't know, I came in with a conservative reputation, and I don't think conservative means you're against the proper functioning of courts. I think it means, let's make them work all the better. That's my goal. My goal is to make the judiciary work better, to make this institution stronger, more effective for all of you and all your clients, which are really our customers. I think one of the things that we need to do when we have this communication with people who are concerned about this is, number one, the message of the courts are perfect and judges are perfect is not a good message. It's not a winning message. It's not an accurate message. I make mistakes on a regular basis. I'm a human being. And really what the message is the system and the people that are in it are doing the best they can, and we are constantly trying to make it better. And that's what appeals are for, that's what reviews are for. So it isn't a matter of we get mad about one decision and we want to throw the whole system out the window. That's never been the deal in America. It's never been the deal. It's let's all get into the boat and start rowing. And so number one, I think it has to be participatory. So that's why I'm asking you to go make those connections. And if you're concerned you aren't the right person to make the connections, you probably know someone who is the right person to make those connections. And they need to happen in the next 12 months. So we can have that kind of a conversation going into the next session. But this is not just the next session, it's a regular conversation we're having across this country. But building trust and listening to people with a different point of view is very educational. It's very helpful. If you take the presentation from the Brennan Center, if you look at those slides in the middle that talked about the changing dynamic where the U.S. Supreme Court has made rulings and therefore state Supreme Courts have made rulings in response. If you take that content and you flip it around from the point of view of someone who is a conservative legislator, what they see is they see courts making political decisions, courts making policy decisions, intruding into the legislative arena. And so what they're seeing is, fine, courts, you want to act political, we will give you a political response. And my suggestion is, our goal is to say, we want justice, we don't want politics in the courts. And that means, and that the merits of those could be right, could be wrong, but that's the conversation to happen. And by doing that on a human to human level, and not necessarily, spitting on each other's arguments, but listening to each other's arguments and disagree. But that's the reasonable discussion that we need to have. In America, we've always had that, back to the football, we've always had that argument between the 40-yard lines. Let's keep having that argument between the 40-yard lines. We do that, we're gonna be okay. What I don't wanna see is things come off the rails and now judges can't do their job, lawyers can't do their job. People can't get a dispute resolved without court is one phase, violence outside the courthouse is the next phase. That's not the future that we all want. So thank you all for coming. Thank you, Natasha, for putting this on. That's my request.
Well, thank you to all of our speakers today, and, here comes the guilt trip, right? So, you heard our speakers today, and what we need to do is get out there and be a part of the solution, and we have 12 months to do it. And so if you're complaining about what's going on in Helena or in the courtrooms or across our state of Montana, you better ask yourself what you're doing to help improve that solution, and we have 12 months to do it. Again, I'm not affiliated with Friends of the Third Branch, but I'm personally ashamed of myself and my lack of engagement, and so I'm passing my shame to you, so that we can wallow in it together and do better this next year. Part of that is showing up face to face and not zooming it in. And part of it could be giving money, and so I'll give a little pitch for the Friends of the Third Branch. What they've done in the last session cost a lot of money, and they're out of it. There are opportunities to donate, and writing a check can be a way to help. It can. In addition to that, get out there and talk to people, because with your JD comes power and responsibility, and it's all of our obligation to use it to help our great state of Montana be better than it is. So thank you for your time today, and thank you to all of our speakers today, because they are the people doing the work in the trenches. So we appreciate the service. Have a good one.